Okay, reading impeachment and rehabilitation evidence from Chapter 7. Introduction of evidence that suggests a witness's testimony lacks credibility. Evidence qualifies as impeachment if it is relevant. It suggests that a certain witness lacks credibility and therefore that his or her testimony should be disregarded. Evidence qualified as rehabilitation if it is relevant because it refutes impeachment evidence. This comes from 607, at least impeachment does. What I have on the note card is that the credibility of a witness may be attacked by any party, including party calling the witness, if prior inconsistent statement would be inadmissible hearsay and can be entered for impeachment, but this is limited at criminal trials by prior inconsistent statement. My other note card says introduction of evidence that suggests a witness testimony lacks credibility. The 5 modes of impeachment are dishonesty, consistency, bias, incapacity, specific contradiction. Rehabilitation, on the other hand, is the introduction of evidence that suggests a witness's testimony, in fact, is worthy of disbelief. Of belief, honesty, consistency, disinterest, capacity, and specific corroboration are the 5 modes of rehabilitation.
That sounds familiar.
And character for truthfulness is from 404A. Generally prohibited a person likely acted in conformance with proclivity to lie. 404A, traditional exception to character prohibition. So there's 5 main attacks of a witness's credibility. Proof of prior inconsistent statement, bias, which is kinship, hostility towards opposed party, pecuniary interest, character attack, religious beliefs are off limits, and the fact that of a witness ability or capacity to observe, remember, count, specific contradiction, other witness, document, physical evidence is saying it in another way is more specific. Procedure Article 4 of FRE and Analytical Framework 401-03, intrinsic on stand. Okay, so intrinsic impeachment happens on the stand during cross-examination. Extrinsic is by defense's case in chief. And next page, 608 is the discretionary rule that applies to all types of character impeachment evidence except prior convictions. 609 describes what court may and may not admit evidence of prior conviction. And prior inconsistent statement. Impeachment showing the witness was told a different story in the past in 613. Rejects a rule that prior written statement could impeach, which means that a written statement can impeach. And then, and this is FR 613, allows extrinsic evidence of witness is prior statement only if witness was available to explain or deny and opposing party may question. FRE 806 is entered here, prior inconsistent statement to impeach hearsay declarant. And 607, prior inconsistent statement may be admitted to impeach by hearsay, either party, even the party who called the witness. Providing that the credibility of the witness may be attacked by any party, including the party who called the witness. Prior inconsistent statement would be inadmissible hearsay. It can be entered for impeachment, but this is limited at criminal trial by prior inconsistent statements. That's everything before entering bias and incapacity. So that's everything, kind of everything besides what the cases say about prior inconsistent statements. Prior consistent statements, which the reason why prior consistent statements is within the bias and incapacity section is for a reason. So what I'm going to do is I'm going to read from the rule what it said, what the FRE says about those particular sections that I just rattled off. Starting with 613, here's the witness's prior statement. Showing or disclosing the statement during examination. When examining a witness about the witness's prior statement, a party need not show it or disclose its contents to the witness, but the party must, on request, show it or disclose its contents to an adverse party's attorney. Extrinsic evidence of a prior inconsistent statement. Extrinsic evidence of a witness's prior inconsistent statement is admissible only if the witness is given an opportunity to explain or deny the statement and the adverse party is given the opportunity to examine the witness about it, or if justice so requires. This subdivision B does not apply the opposing party's statement under Rule 801 D2. Okay. So it's any other witness, but 801 D2 applies to the opposing party witness. Is this the same thing on my note card? Allows extrinsic evidence by witness's prior statement only if witness is available to explain it or deny it. So it requires availability. All right, and it's not an opposing party's witness. So that's 613, but we started this off talking about 607, which we read a couple times now, so that's fine. 608 is this discretionary rule. There's 609, 601, 608, character for trustworthiness. I just read this also. Reputation. 608 is a witness's character for truthfulness or untruthfulness. Reputation or opinion evidence. A witness's credibility may be attacked or supported by testimony about the witness's reputation for having a character for truthfulness or untruthfulness, or by testimony in the form of an opinion about that character. But evidence of truthful character is admissible only after the witness's character for truthfulness has been attacked. We keep talking about bootstrapping, and that's it right there. Bolstering. I'm sorry, not bootstrapping. Bolstering. Specific instances of conduct, except for a criminal conviction under 609. Extrinsic evidence is not admissible to prove specific instances of a witness's conduct in order to attack or support the witness's character for truthfulness, but the court may, on cross-examination, allow them to be inquired into if they are probative on the character for truthfulness or untruthfulness of the witness or another witness whose character the witness being cross-examined has testified about. By testifying on another matter, a witness does not waive any privilege against self-incrimination or testimony that relates only to the witness's character for truthfulness. And then 609 describes what the court must, and may not admit as evidence of a prior conviction. And I believe we just read this too, or maybe not. This is 609, impeachment by evidence of a criminal conviction. In general, the following rules applying to attacking a witness's character for truthfulness by evidence of a criminal conviction for a crime that in the convicting jurisdiction was punishable by death or by imprisonment for more than 1 year. The evidence A must be admitted subject to Rule 403 in a criminal case or a civil case or in a criminal case in which the witness is not a defendant. And B must be admitted in a criminal case in which the witness is a defendant if the probative value of the evidence outweighs its prejudicial effect to that defendant. And I have no idea what I just read because some stupid idiot thinks that I care about his stupid text messages on a fairly consistent fucking basis. In general, the following rules apply to attacking a witness's character for truthfulness by evidence of a criminal conviction. I need to mute that person. For a crime that in the convicting jurisdiction was punishable by death or imprisonment for more than 1 year, the evidence must be admitted subject to Rule 403 in a civil case or in a criminal case in which the witness is not a defendant, and must be admitted in a criminal case in which the witness is a defendant if the probative value of the evidence outweighs the prejudicial effects of that defendant. And all of this is really probably can go without being said. For any crime, regardless of the punishment, the evidence must be admitted if the court can readily determine that establishing the elements of the crime required proving, or the witness is admitting a dishonest act or false statement. For any crime, regardless of the punishment, the evidence must be admitted if the court can readily determine that establishing the elements of the crime required proving or admitting a dishonest or false act or false statement. I think this is the crimen falsi, the source of the crimen falsi doctrine that I've been talking about. Limit on using the evidence after 10 years. This subdivision B applies if more than 10 years have passed since the witness's conviction or release from confinement, or for it, whichever is later. Evidence of the conviction is admissible only if 1, its probative value supported by specific facts and circumstances substantially outweighs its prejudicial effect. The proponent gives an adverse party reasonable written notice of the intent to use it so that the party has a fair opportunity to contest its use. So you notice, it needs to be 403 approved. Effective pardon, annulment, or certificate of rehabilitation. Evidence of conviction is not permissible if the conviction has been subject to any of those things, or equivalent procedure based on finding that the person has been rehabilitated and the person has not been convicted of a later crime punishable by death or imprisonment in 1 year, or the conviction has been subject of a pardon, annulment, or other equivalent procedure based on a finding of innocence. Juvenile adjudications. Evidence of a juvenile adjudication is admissible under this rule only if it is offered in a criminal case, the adjudication was of a witness other than the defendant. An adult's conviction for that offense would be admissible to attack the adult's credibility, and admitting the evidence is necessary to fairly determine guilt or innocence. Pendency of an appeal. A conviction that satisfies this rule is admissible even if an appeal is pending. Evidence of the pendency is also admissible. And that's 609. And therefore, we can advance. Although FR 806 was talking about prior inconsistent statement to impeach a hearsay declarant. Did I mark 806? Attacking and supporting the declarant's credibility. When a hearsay statement or a statement described in Rule 801D, 2C, D, or E has been admitted in evidence, the declarant's credibility may be attacked and then supported by any evidence that would be admissible for those purposes if the declarant had testified as a witness. The court may admit evidence of the declarant's inconsistent statement or conduct regardless of when it occurred or whether the declarant had an opportunity to explain or deny it. If the party against whom the statement was admitted calls the declarant as a witness, the party may examine the declarant on the statement as if on cross-examination. Declarant's inconsistent statement of conduct. We're not necessarily talking about a witness. Okay, the declarant's credibility attack. Okay. But it's mildly different. Hearsay declarant is how we're referring to it. That's the key distinction. Everything else operates probably very similar. FRE 67, doesn't matter who's doing the impeaching. Okay, bias and incapacity. Proving witness or hearsay declarant has reason to lie or slant testimony. Being paid, pecuniary interest, gang relation, romantic involvement, diminished memory, perception is unreliable, such as bad eyesight, delusions, but does not run afoul of character evidence. And any rules? No rules yet noted here, but the cases start going into prior consistent statements introduced to rebut a charge of recent fabrication or improper influence or motive was admissible if the statement had been made before the alleged fabrication came into being, but inadmissible if made afterwards. The next page has like the same idea going on, prior consistent statement limitation when there is a motive bias issue. Prior consistent statement introduced to rebut a charge of recent fabrication or proper influence or motive was admissible if the statement had been made before the alleged fabrication came into being, but inadmissible if made afterwards. Same exact thing I just said. Specific contradiction. Okay, so this has a code or a California Evidence Code citation. So I'm going to mark this page. I'm going to mark this page because with the note card to expand upon it because it has a CEC citation. It doesn't have an FRE citation, but I can tell how it's kind of embedded in there. Others, just from reading them out loud, can't specifically say which, but the next one is specific contradiction. Impeachment by specific contradiction demonstrates a particular part of what a witness has testified to as false, and suggests that this gives the jury reason to disregard the remainder of the testimony. And distinguish from impeachment with prior inconsistent statements, for example, impeachment by self-contradiction. Distinguish from collateral evidence rule. Judge made restriction on impeachment by specific contradiction that bars extrinsic evidence by specific contradiction on a collateral matter, narrowly defined as a fact in question could be proven for any purpose other than contradicting the witness because it avoids derailing trial and decided issues. Okay. 608 evidence solely for the purpose of enhancing a witness's credibility before that credibility is attacked. 608 provides specific limits on admissibility of rehabilitation evidence until character for truthfulness is intact. So that's not related. Just reading it because I thought it was. This whole thing about impeachment with prior inconsistent statements is distinguishable from specific contradiction, and then the collateral evidence rule limiting it. So what exactly is specific contradiction and where does it come from? Because I don't have an actual citation for it. I might put another note card here to figure that out, but I don't think I'm going to figure it out. But I love the idea of this collateral rule. So I'm just going to mark this page. Both of these things are pretty awesome. Collateral evidence rule. Judge made restriction on impeachment by specific contradiction that bars extrinsic evidence by specific contradiction on a collateral matter narrowly defined as a a fact in question to be proven on any purpose other than contradicting the witness, because it avoids derailing the side that she's got it. And then moving on to the next page, consistency, disinterest, capacity, specific corroboration, bolstering, simultaneously rehabilitating, which is simultaneously rehabilitating a witness before he's impeached, which is impermissible. It's talked about in FRE 608. Character evidence in support of credibility is admissible under rule only after the character evidence, witness character has been first attacked. It seems a lot of time. Example of an attack is a character of truthfulness, misconduct, untruthfulness, probably prior conviction. And then there's some cases, and we get into chapter 6, trial strategy. You could bind everything in enrichment and character. This is crazy. Got like 12 more minutes. So the trial strategy is probably, the 611 is about the order. The 106 is about completeness. And 611 again. 615, witness regarded as hostile without much demonstration. Well, what the heck is that? I don't get into any of the privileges, but that's okay because I kind of know them. And then authenticity and best evidence came shortly after that. Let's see what 615 talks about. 12, writing used to refresh a witness's memory. This rule gives an adverse party certain options when a witness uses writing to refresh a memory while testifying or before testifying. If the court decides that justice requires the party to have those options. Deleting unrelated matter. Failure to produce or deliver the writing. I'm talking about striking his testimony and declaring a mistrial. 613 is about witness's prior statement. Right. Okay. So if you're trying to contradict somebody, or I'm sorry, if you're trying to refresh their memory, you really need to have a document of what it is that you're citing, or the record that is for recollection. So an officer or employee of a party which is not a natural person designated as a representative by its attorney is the note card definition of Rule 615, which is titled Excluding Witnesses. And I think it is, what's the word for it? Sequestering witnesses. And I'm going to just leave it at that. I'm not going to read all of the reasons why that matters. SOR, standard of proof review for 611, the mode and order of questioning to be overturned on rare, clear abuse of discretion that seriously damaged a party's right to a fair trial. I really like the definition. So this is 611A. Just so you know, 611C is the use of leading questions on direct exam required, either showing of actual hostility or a determination that the same witness being examined was an adverse party for purposes of this rule. That's great. I'm going to use it to mark this standard of review on 611A about the mode and order of the trial. Questioning by the judge from 614. Can't be far off from here. Court's calling or examining a witness, examining objections. The court may call a witness on its own or at a party's request. Each party is entitled to cross-examination of the witness. These are my markers. Examining, the court may examine a witness regardless of Who calls the witness? Objections, the party may object to the court's calling or examining a witness either at the time or the next opportunity the jury is not present. So you don't want it to backfire. 614 court questioning. All right, and that concludes kind of that. Tillman is a good example of it. Being really sarcastic. And there's all these minority majority rules, right? Minority of jurisdictions allow questioning by jurors. I'm sorry, that's what I would say. Questioning by jurors is only in a majority of jurisdictions. Forbidden inferences. And another way to refer to that from my issue spotting checklist is calling them extrinsic policy exclusions. So I'm going to say AKA forbidden inferences. And those would be drawn from what it says here. And I'm just going to give the code since we're running out of time. Subsequent remedial measures is 407. Civil settlements, 408. Criminal settlements, 410. Medical payments and liability insurance, 409. I guess I haven't actually read this there. It's also 409. And 408 allows free communication not admissible as evidence compatible with exclusionary. So I'm gonna say, yeah, that's 408. Okay. And there's a bunch of cases. I didn't highlight any text in there. 409, 411. It's about insurance and medical expenses. So medical expenses can also be like when the hospital subsidizes them. 411 is the liability insurance, probably a bit better than 409. Competence, 601, which is really broad. And there's a lot here about, what was it, 601? Competence. Proof. Witness is competent. Basically, if they have personal knowledge, right? And all the historical approach of like excluding people is not the modern approach, which is more inclusive. Now, morality standards were 603 as by way of post in affirmation. I don't even know what that means. And then 610 is religious grounds and criminal conviction. 610 marital relations. 506 as a privilege. Personal knowledge is really the only requirement, and that's actually 602. And what else do we have? More cases. Opinions, experts, and scientific evidence is 701. All right, so 701, all of my 700s have to do with witnesses. And I kind of guess that lay opinions require firsthand observations. I like the way of saying firsthand observations rather than personal knowledge. firsthand observations. Okay, that's better. 701 allows lay opinion that is rationally based from firsthand perception and helpful for clear understanding. 704 does not find lay witness testimony objectionable because it embraces an ultimate issue. Okay, that's about conclusory. Okay. This is conclusory lay testimony, not objectionable. That's good. What else do we have? I was reading a sample answer about expert testimony and was saying knowledge and experience, and it was saying helpful to a jury. I got that much. They're saying something about conditional. It's not conditional relevance, but the inputs of the expert's report need to tie back to some. Then it's somewhat reliable. Okay, 702, skilled witness can, right. I don't know, it expands or distinguishes. 701, 703. I really don't have anything on that. 704, to avoid conclusory opinions. 706, court-appointed experts. Okay, I shouldn't be considered completely infallible. Judicial scrutiny of parties approved. I'm gonna skip all that. Lie detection. There is a code on that in machine code. CEC 351. Let's find it, but in so doing, let's read some 701. Here we got no testifying about inferences or conclusions, only facts. No testifying, expressing opinions on the ultimate issues of the jury. Modern statute allows lay witnesses to offer opinions even in the ultimate issues if based on first-hand observations. Don't in common law don't reach any legal conclusion, conclusory opinion. Okay, so this is all like 701. There's 702 is testimony by expert witnesses. So they're saying qualified as an expert, knowledge, skill, experience, training, education may testify in the form of opinion if otherwise scientific, technical, or other specialized knowledge will help the trier. So helpful. So here's knowledge, training, experience, education, helpful, scientific, technical testimonies based on sufficient facts or data, product of reliable principles and methods, and expert has reliably applied the principles and methods of the facts of the case. That's great. Practically applied. Basis of an expert's opinion testimony. An expert may base his opinion of facts on in the case that the expert has been made aware of or personally observed. If the expert in the particular field would reasonably rely on those kinds of facts or data informing, it's like reasonableness. They need not be admissible for the opinion to be admitted. But if the facts or data would otherwise be inadmissible, the proponent of the opinion may disclose them to the jury only if their probative value helps in 403 analysis. 704 opinion on ultimate issue. Okay, this is a conclusory. In general, not automatically objectionable. Okay, so here's the exception. To criminal case, an expert witness must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged in offense. Those matters are for the trier of fact alone. More about the underlying facts. 704 court-appointed expert witnesses. That's right. 706. Before jumping in Thursday. So I'm going to scroll to CEC 351 just in case someone it's just there. 356, 351, 351, 351, and this one is up top. Polygraph evidence. That's what it is. Chapter 9, opinions, experts, and scientific evidence. Okay, there's really I guess you could talk about what kinds of evidence. There was the probabilistic evidence, trial by mathematics. There was a case that was applying the Bayes theorem and DNA testing versus the traditional forensic sciences. And there's all these treatises about it and how reliable it is. And handwriting, Daubert. Handwriting is 45% unreliable. Daubert, I didn't want to look at that a second time. Privileges, 501. Now, communication and confidence between a lawyer. ACP, in the course of providing legal services not waived, privilege belongs to the client, and there's a bunch of cases about it. Crime fraud exception. I love this one. And I have 1 minute. Spousal privileges. I recall them being in 502 or something. I just said it out loud. Here's privileges. 501, privilege in general. Why do I care? There's attorney-client and work product. Join. Where's spousal? Not even here. Simply joining. Ending the recording.